We'll come to order, and since this is Senator Tom's bill, I'll allow him to lead the discussion.
We've actually spent quite a bit of discussion on Bill 224, and that is the bill that deals with the legal and contractual remedies in Guam's procurement law. I don't know. I read the testimony that was provided by the OPA, and I think the concerns that you raised have been addressed in here. For example, you raised the issue about that in order to, before you can go to the Superior Court, you've got to go through OPA first, and then after that you can go to the District Court, Superior Court. The issue about time standards, we discussed that. There has been in the law that there's a bidder will have to submit his protest within 14 days from the time that he knows. So that time standard is there. The government will now have the time standard as to when to respond. Under the current law right now, it doesn't have to respond. It doesn't, chooses not to. But now the amendments that's being proposed in 224 actually does provide that time standard. There's a time standard as to how soon, when then, after determination is made that an adverse decision has been made to a protest, there's a timeline as to when it can be elevated up to the OPA, and similarly, I think there's also a time standard as to when you need to file with the court. So I think what you've raised in your testimony have been for Bill 224 have been addressed. Now, I don't know if anybody else has any particular concerns that they want to raise with regards to Bill 224. Kevin, I don't know whether you've had a chance to review 224 in its where it has evolved to today. But does anybody have any? Yes?
Well, my own plain reading of this, and this is why the hearing officer Anthony, who has been my primary, I was concerned that agencies or protestants will go to the Superior Court, and there have been a number of opinions, the most recent opinion affecting telecommunications saying that they need to come back to OPA. And so I think the court also has this, but maybe I have to go back and read it again, but my somehow plain reading of it, I wasn't quite sure that it said that. And of course, the other concern we have is regarding the regulations, and at least regulations that changed where the law is changed to ensure that the regulations also follow suit. And so maybe there should be language, because I know at least that the version that was sent out, did not have that. And so those really are the concerns. And then, of course, I'll go back. I'll have Anthony go back and look again about the uniformity of time, because we don't want to be different from what the courts would require. We want to be uniform so that everybody has a common knowledge. So those, 224 is really what affects OPA the most. 226 is really just about the bidding and everything else that would affect all the agencies, plus Claudia, plus the AG's office. But 224 is really more the heart of the matter vis-a-vis OPA and that process. So that's why more of my emphasis was on 224 than on 226, because that is more technical, and that's where the legal beagles will kind of slice and dice accordingly. But I just wanted to make that general comment. Thank you.
Anybody else have any comments on 224? John?
Thanks. I'd just like to point out, there's an amendment in 5480E, which says no action shall be... Page 19. and exhaustion of administrative remedies is the title. And it says, no action shall be brought under any provision of this section until, and this section has to do with going to court, until all administrative remedies provided in this chapter have been exhausted. That's about as plain as we can get that.
Thank you very much. That's good. Thank you.
Okay.
My only comment, Senator, was that I think my office...
Please.
Excuse me. My comment would be that I think my office would like an opportunity to at least look at the changes. See if it's relatively good here if you want to comment. Other than that, we have nothing to do to
And I do want to say that the AG's office has been very helpful in that if it saw things differently, it flagged it, but then also gave recommended language as to how we might then correct it.
We are in probably a busy season right now because of the end of this year, and at least the lawyers who would work with this, because there are lots of solicitations and contracts that we're trying to get done before September 30th. But having said that, if there's a deadline that you'd like us to move on.
And I think a quick read, the AG's office will find that really a lot of the changes in here, it has been involved from the very beginning and has actually incorporated many of the suggested changes. Anybody else? 224. I think before we put 224 away, I would like to, and I really don't know how we're going to address the issue of the regulations. Are we going to attach it? Do we introduce it as a separate bill? I'm at a loss.
I think why don't we just make the request at this point to the AG's office to do the legal opinion as to whether or not we can amend it by law. And John, I know you haven't.
Yeah, I have a suggestion, and it came out of reading the comments from the public auditor about the power was taken away from the public auditor to write certain regulations because the public auditor has had those powers for 10 years and hasn't written the regulations, so give it to somebody else who's going to sit on it for a while as well. But that got me to thinking that perhaps we could have a provision in the bill that said that regulations can be drafted by the public auditor, which could be superseded at some point by the policy office if they get around to it. But in the meantime, the public auditor could provide all the regulations that come out of these two bills.
Or alternatively, the AG's office could be the one. Or
But you already had the power to write some of the procurement
Yeah.
regulations. So what I'm saying is, consistent with that, instead of adding yet another author to the list.
Why don't you speak? I want him to, because he's going to be the one doing it.
Trying to tell the public auditor essentially it's probably better if she did it because she doesn't really have a stake in the actual procurement action itself like the agencies would, like the executive branch would. And as an independent body, it's probably better that these regulations come from an independent body. Of course, what I did enact and what you do find, I tried to mirror the regulations to the changes with some of the changes we had in there as well. So it doesn't quite track the changes to the most recent bill, but at least if you want to provide it digitally, it would be an easy form for you to do that if the legislature decided to do it itself. I could provide it digitally, so it's easy to revise it even further, the regs, and basically put whatever the new amendments.
Provide what digitally?
Yeah, our testimony, so that include the regulations. So that would help, or basically if the legislature decided to amend it themselves, it would expedite the process. But yeah, but my position at least is that it's probably better that the OPA draft the regulations, just because of its independence, that's all.
And it's an executive body, not
Yeah.
not a legislative body.
If I could only, the one concern I would have, though, is because of the effective date. I think for this to be really clean, both the regulations and the need to be in sync. We don't want to have the law first and then have an appeal where the regulations are still being drafted. So maybe we need to change the effective date. And again, it just depends. If it's done by law, then it's no problem. If it's going to be done by OPA, we're going to need a little bit of time because we have to go then through the AAA. And that's my concern. That's really more the concern, because it says it will be effective 30 days upon passage, and if the regulations are not attached, then to develop them, to have the AAA, you're talking at least a minimum, even 30 days, 90 days, and then it gets transmitted to the legislature. They have 30 days upon. So you're talking almost 6 months. And either you change the effective date of the law to say 6 months afterwards, or, rather than 30 days, because we don't want the law and then the regulations, from the loophole from the regulations. That's the concern that I raise. And so from a cleaner perspective, I can task Anthony to give it to you and have the proposed regulations so that upon passage, the regulations only that affect those sections would be changed and everything else remains the same because of the substantive change in the law.
All right. And what I'll do is I'll check with our legal counsel as to the mechanics of, do we put it on as an Appendix A or whatever, and so that when the law is passed, with it comes the affected regulations as an appendix. Okay, well, I think we got that resolved, and pushing to have this thing done before this term is out. I don't want to go through all this multiple roundtables again.
We agree.
Okay.
It would be very good.
If there's no further questions on Bill 224, we can go ahead and proceed on to Bill 246, which has to do with source selection. And also, what I want to do with both bills, I would like to do, Mr. Chairman, with both bills, is to delete Section 1, the findings and intent. Through experience, you find out that sometimes it takes us a whole day just to get through the findings and intent, which has no force and effect. So I'll just keep that for my own reading material, and when the bill gets reported out, we'll just go to the meat of the bill itself. We can go ahead and let's see. Does anybody have any suggestions? We can go section by section. I don't think we touched on this in the last round. Although I think we did get testimonies.
There was a public hearing.
Well, there was a public hearing, yes.
There was a public hearing, but as I recall, Senator, it was kind of understood at the beginning of the hearing that it would resolve into the to this kind of a meeting for the really substantive discussion. So I'm not sure you got a lot of really useful information at the initial public hearing. That's my sense.
Yeah. The only thing that we've gotten on 246 so far is we did get a on July 24th testimony from the Chamber of Commerce. Testimony dated September 4th from OPA, and other than that, I don't think, do we have any other testimonies? I believe, yeah, I believe.
And the AG has submitted
Yeah, I got the Chamber of
testimony
Commerce.
as well.
Bring it down. We did receive testimony from, that's 224. testimony of the AG on Bill 246, from AMI on Bill 246, Triple J, AM Orient. So we did get testimony from the AG's office and from OPA, and that's really about the extent of the testimony. Oh, and let's see. Do we have one there from DOE? If you say we have, we did. And we have looked at these testimonies, and we even got one from the University of Guam. And we've looked through those testimonies and have incorporated. Yes. And so we've looked at those testimonies and have incorporated them, and then we've had, I don't know that we touched on it on any of the round tables.
No, we really did not.
We did not.
No.
at
We never
all.
got to it.
Yeah.
So,
Roll up our sleeves.
we can go section, I don't know, does anybody have, I think, John, maybe, I'm going to go ahead and ask you, maybe you can kind of summarize. You're the one that's kind of memorized this thing.
Well, there's some big hitters in here that are obvious. I think everybody's aware of them, which is the reintroduction of the competitive sealed proposal method. We're calling that the RFCP because we want to keep the RFP for professional services. The model code has basically eliminated the RFP for professional services, and they acquire their professional services under the RFCP. But I think that there's a distinction between the two, in that the RFP for professional services deals with price after they've selected their preferred awardee. And in the RFCP, price is a factor to be considered in determining who will be the awardee. So I think it's appropriate to have those both sections just used appropriately, not just willy-nilly. So that's one of the big hits, and the other big hit is the bridge contract, which I know is just replete with moral hazard, and a lot of people cringe at it. An equal number of people, or more actually, that I've spoken to really like the idea. It will take some of the onus off of doing things illegally, because you're going to have to get things that's what this is about, is ongoing supplies or services. So it was in there, and that's a very controversial one. There are other tweaks that come to mind, particularly are in the emergency procurement. And that one, we stick to the basic theme that it's a 30 days supply of goods and services for an emergency procurement. But it can be 90 days when the emergency is a natural disaster. Because, we have a lot of emergencies on Guam that aren't natural disasters. They're man-made disasters. And we don't want to encourage those. Those are the really big ones that are in there. And a note that it's in the 224.
If I might just interject here, if anybody's wondering why I asked John to kind of summarize all the changes, I work collaboratively with John. He's very familiar, of course, with the code itself. And the role that I played was to put it into language that will pass muster down here at the legislature, and just getting it along through the process. And then, of course, being able to take it on the floor. So that's how that collaboration is working.
Senator Manston, I believe Retirement Fund submitted their position on 224.
Yes.
There was no mention of that. 246 we did not yet. But 224, I believe, according to the director, was submitted.
Well, did you look in here to see whether you're, I mean, I've gotten so many testimonies, I forget exactly what.
No, I'm just wanting to confirm that whether
Yeah.
it was received or not.
I recall seeing it handed out at the second round table.
Yeah. And have you had a chance to look through 224 to see if, in fact, your concerns have been addressed?
No, I just got a copy of the bill on the 28th.
No, there's a brand new one.
Yeah, I just got it on August 28th, the substituted one.
No, there's
there's-
substitute was as of yesterday.
Oh, okay, no, I haven't got
No,
that one.
that one,
That's what you have in this package.
Oh, okay, this one. No, I haven't had a
So go
chance to
through
look.
that one and see whether or not your suggested amendments are included.
Okay.
Um, is any, well,
Yeah, I think that there were some comments made about taking 5212 out and not putting it back anywhere. 5212 is currently the bid bond section for supplies and services. There was never any intent to take it out. That got a lot of steam in some of the comments. It was meant to just put it in a different article. There's a bid bond requirement for construction in Article 6. The appropriate one would, or in Article 5, the appropriate selection of a place for that bid bond and for goods and services would be in Article 6, which does concern itself with supplies and services. So it's been renumbered, but I don't think it was modified in any way, any significant way.
and you'll find that deletion of the repeal of 5212 with regards to the bid bonds on page 7, section 6, and there it just basically says it's repealed and then reenacted in Article 6 of Chapter 5, Title 5 as a new section 5351. It appears that I guess everybody is looking at this bill 246 probably for the first time, and so I don't know that we're going to get too far today to discuss this bill, other than I guess what John has pointed out. And if there's any testimonies, additional testimonies anybody wants to send in, I guess we'll leave the books open for another couple of weeks.
We did submit testimony on it, and there's just a couple of things that we just wanted to point out. One was in section 9, let's see, about requiring the errors and omissions. That might be, and maybe the attorneys here, I don't know how many have errors and omissions liability insurance. So that was one section where we said we'd like to see be eliminated, because it might be an owner's burden for some of the smaller firms. Maybe a firm like Carl Smith may not, already have it, but some of the smaller firms, I don't know, may or may not have it, and I don't know. And so we had suggested omission, but if the attorneys want to keep it in, I'll leave it up to, I don't know yet of all of, I know the Deloitte's and the EYs of the world probably have that, but I don't know if everybody else does.
I don't know that that's in section 9. Well, you stated in your testimony,
Yes, it's
section
section
9.
9.
Section 9, it's page 17, subsection F of 5216.
Then the other area that I think really deserves a discussion is on the bridge area, and I think we oppose that in its entirety, and that is section 13, and that was the new one you talked about. And I think the reason why we've done that, because to me that just it entices poor planning. It already takes enough time as it is, and agencies really need to be disciplined to ensure that, they get out their IFBs or RFBs, way before the time. And to allow this just gives them the opportunity then to do it again. So that's why, in principle, we're opposed to it. I understand the rationale, and maybe language needs to be such that there will be few exceptions.
Yeah, I think that the prime example is specific PDS. I think with DOE, right? I mean, with telecommunications
No,
contract.
that's an entirely different issue.
Which one?
Yeah, which one? Okay, that one's different. Yeah, depending on which, because we've got, the one with the communications is a new one, and of course, that is now before Judge Borsinas has brought back for us to relook at that entire bid, but I think the AG's office is opposing it because there's another aspect of it going to the Supreme Court. So, but even then, there needs to be that discipline, is where I'm coming, the discipline for agencies to,
I think the major problem is more the copier services.
Well, copier services too was another one
Well,
that
that's
never.
Anything like that.
Computers.
We're almost there.
Anything that's not going to toilet paper.
Yeah,
No, I
So-
think the big issue with this is the policy, the government of Guam policy for procurement requires proper and adequate acquisition planning.
Yes.
That is part of when things get implemented, how they get implemented, which needs to be incorporated into the bids or the RFPs. If they're not, then that's a deficiency on the acquisition planning area. So to allow this, it almost makes or forces an agency to forego that acquisition planning process to plan properly. And so if they don't do that, this is just their way of escape from failing to do that. And so
Well,
representing,
they do it today using the RFQ process, which
well,
I haven't seen an RFQ process that's been legal ever.
and I'm not arguing that point either, but because they're using the emergency procurement, and I beg to differ as to whether they can use it, because it's not life or death. But they're using it. But that's because the way they employ the IFB, they didn't plan for these things. But if they adequately plan for it as required by the policy of the procurement, I mean, remember, you're using taxpayer dollars. And when you use taxpayer dollars, you better lay out every route that you're going to do. So the taxpayers are aware of the process and it's transparent. If it's not, and you allow these types of things, then you're sort of sliding the taxpayers. And that's the reason why I think the bridge thing is a bad thing, because there is, in effect, the acquisition planning requirement. As a matter of fact, in the law, it requires from day one, the minute you say you need something, you have to have in that procurement record why you need it, the studies that you use to determine your specifications. All of that has to be in the bid. If it's not, you cannot award. That's the way the law is now.
The rationale behind it is to find a practical means to keep the government from daily doing something illegally, because they roll these things over daily. They use a wrong method every time. And so what do? There's no penalty for doing it illegally. They're just doing it illegally. And that kind of demeans the whole process as well. Now, of course, it detracts from the planning. The best practices guide that we have to procurement planning is in the federal regs in Article 4, Part 15. It's a beautiful detailed list. If we only followed that, we'd be good. If they only followed it, we'd be good. This planning for this bridge contract, or they call it a follow-on contract also in the federal regime, the bulk of the contracts that they're writing these days are bridge contracts and follow-on contracts, because it only applies to continuing, ongoing goods and services that you need to acquire. And for some reason or other, time runs out. Typically, it is bad planning, but they enforce their planning a whole lot better than we do. So they're still having the problem, things popping up. And rather than be accused of doing it illegally, and they have to have it, I mean, we've seen all these emergencies declared because these are essential to the operation of the government. That might work once, but when you have that rolling over every month and you got that same essential, you've got to have it. We know that they got to have it. We're just trying to put some legal cover. What this does, incidentally, is it raises the visibility of this, because right now we don't know how often this is happening in the government, and the CPO has to sign off of this, because the CPO has supervision of all territorial procurements of goods and supplies and services, and the governor has to sign off on it. And that's going to pester them. Every time it comes up, they've got to sign off on allowed to do that. And if you get pestered, you're going to say, what's going on down there? You're going to enforce it. Right now, nobody enforces it. There's no mechanism to enforce it. And so, when you look at it from that perspective, it has some validity. My heart is not into this. It goes against everything that I can think about in terms of planning and all the real principles behind this. But it's a practical solution to an everyday problem that needs a fix of some kind.
John, just to state for the record a correction, not all contracts go through the CPO. For example, professional services contracts I don't see at all. It goes direct, just the agency, the procuring agency to the agency. But
that's right. You don't see that, but you do have the legal duty to supervise the acquisition of all supplies and services under 5113C.
That's correct. If I'm aware of what they're doing, but a lot of times, like you say, and agencies are required to submit actually a list to GSA, to file with GSA all the request for proposal contracts that's out there. And we do send out that circular reminding them to submit that to our office.
You need three of you.
Yes, I know. Thank you.
Senator, one of the other things that I guess that bothers us about this bridge mechanism is that, I think it actually reduces accountability. It doesn't increase accountability. I mean, this section C here that says that there shall be no protest or appeal of award of a bridge contract. I can tell you from my experience in government procurements, so many times procurements go off the rails and are just awards are made that need to be looked at and through a protest process or an appeal process. And this basically excludes it and allows those things to go on for as long as 9 months. So in our business, what happens is that they could go out and they could select someone and then basically that person becomes entrenched in that bridge period. And we get an IFB that comes out later on that says delivery in 2 weeks. Okay, and because that incumbent is entrenched and already delivering services or their product, it's almost impossible for a new entrant to come in within that timeline. Without being able to, in a legitimate case, protest the original award, then it creates a backdoor way to create that entrenchment of an incumbent provider. So that would be our concern. And I understand that our services is a reoccurring services type thing that basically once it's established, it does roll over year to year and things like that. But and the government doesn't do the planning. I agree with that. I mean, we're in September. I think we have 2 government agencies that we deal with that actually went out ahead of time and did procurements back in July and August in preparation for the new fiscal year. No other agencies have. That was the Judiciary did it, and also GURA. None of the other ones that we deal with have done any procurements for the new fiscal year. So it's a huge problem, and the government is not meeting its obligations to procure the services competitively. But I don't know if this is a solution.
Well, first of all, isn't it kind of problematic though, because you cannot issue a purchase order or put out an invitation for bid unless you can certify that funds are available, correct? And so they not knowing what you're going to get for the next fiscal year.
I'm not sure that's exactly correct.
Okay.
I don't think you can execute the contract or the purchase order if that ends up being the representation of the contract unless there's funds that are certified. But I think if you've taken every reasonable effort to get an appropriation and you think you're going to have an appropriation, I think you can begin the process with the understanding, and we've advised our clients that you have a clear statement in that procurement, that solicitation of whatever that contingency may be. Because otherwise, it's almost impossible to do what John is saying, which is adequately start the process in time to have something in place by October 1. But it requires an understanding of what the issues are in terms of the planning and the process of having some assurance that there's funding that's probably going to be available to you. Otherwise, it's just irresponsible to start the process. So,
But the reason why I said what I said was I thought there was a block under there when you issue out these things that I certify that funds are available.
when the PO's issued, yes.
No,
but
when the actual contract comes out, there's a block.
Now before that, that certification is made, what has to go in every procurement, though, is a caveat that states that this is subject to funding.
Availability.
Yeah,
Yeah.
availability of
That's all
funding, and essentially, funding is available, and it is right, at the time they do the purchase order, that's when that statement, we certify funds are available, comes in. But before, it only has to be that statement, subject to government funding, that's it.
And we do have a case before, I think it's the Supreme Court, on that very issue about the adequacy of the funding. There is a case right now having to do with, I believe, DMR and the POS. Yeah.
Steve?
I have, a little bit more experience on the federal side, and I guess they call it an urgent and compelling justification, when there's a situation where a contract runs out. And, one of the criteria is, well, the lack of planning can't justify an urgent and compelling circumstances. But like John points out, I think at least now it gives it some visibility into the process, whereas before, government either uses RFQs and stuff, and nobody knows what's going on, where at least now, even though it might not be palatable to some, it gives visibility, and the government certainly needs the flexibility, to be able to have services when it needs it, notwithstanding sometimes the fact that, like all of us, may not plan 100% ahead of the time. So I think it's good to give it visibility, and it's just got to be monitored, and the fact that people could see it, then if it does go on, like Mr. Day says, it gives the opportunity to people to raise the flag.
Okay. Anybody else? There was, I think, let's see, the issue of sole source procurement. I think just a quick look at that. John?
Page 12.
Yeah. I think with that one, it's more limiting in that now the term will be limited to 1 year with 4 successive annual options to renew, but with each, every time an option to renew is exercised, let's see, I believe the
You need to revalidate the sole source.
right, yeah.
Justification.
And then if the sole source is for an amount greater than 50,000, it has to be published on the website. Yeah, that's the change to the sole source procurement.
May I make a comment?
Yes.
We have discussed this in our office because the Attorney General's office is concerned about sole source procurement in general. It seems to me it's not unreasonable to create a requirement for a notice to be published prior to the as sole source being awarded at all, so that the marketplace has an opportunity to come forward and say this isn't the sole source. We have that product. It would require some work. It would require that the specification be published. It would require that there be, and it could be a fairly short notice. It could be 15 days or 20 days or something reasonable. And there would be some cost involved because it would require a publication, presumably. But why not? Because my general advice to my clients who want to do sole source is, well, why don't you just put out an IFB? Because if there's competition, then you're going to get more than one bid, and if there isn't, you're going to get one bid, and then by golly, it's sole source. So the middle ground is to just require a notice and let the marketplace beware this is going to happen. I did an investigation not long ago in a certain area of the marketplace and went back about 5 or 6 years and found 25 or 30 sole source procurements that just, I don't think ever saw the light of day. Many of them with obviously proprietary specifications that in a market that is very competitive. And it just said to me, this is a problem. So my suggestion is that it's not that big of a burden to do that. Now, we haven't put that in our testimony up to this point because honestly we hadn't thought about it from that point of view, but we will give you some specifics on a proposed provision that would, some minimal requirement of notice to the community in advance. That's my thought.
Thank you, John. If I could, I would eliminate the whole section on sole source because in this day and age, there really isn't any such thing as sole source. And I agree, when we did our own audit, so I can't remember what were some of the things, but this was just a way to just bypass and give it out. And I agree, just a simple notice. We did have in the very early days on radio communications that was sole source, and there was a local vendor here, and how they found out is when the award was given, and that's when they protested. So just a simple notice that we want this, rather than just doing it behind closed doors. It's sole source and that's the end of it, and nobody knows about it until either an audit or some other area. Just the simple, and we advise, hey, don't even tread there. If you want to talk to me about, forget it. I just don't think in today's day and age sole source is really a valid area. And just the simple notice of that you want this area is at least will invite competition. And who knows how many other people may be doing that item and you just didn't know about it, as opposed to the so-called traditional source you might have gone to. So sole source has always been a problematic issue, and I agree with John's comment that, hey, just advertise it. Just simple advertisement of the things out there, really it does invite competition and has helped our government, in the area of computers, in the area of telecommunications, in the area of maybe not so much in the area of copying machines, but vendors need to get their foot in there. Certainly in the area of automobiles, it has been good. But when specifications, and this has been the problem, are so tailor-made that only a Ford whatever can, that's where the problem is. Thank you.
Senator, if I may. GSA currently, what we normally do is if we know that a department has, let's say, an equipment that needs parts or repetitious parts ordered, before we issue a sole source, we actually issue out a request for interest, and we list down those, those proprietary, those equipment models or brands. So we do issue out a notices. We issue out a general, in the newspaper ad, a list of all these proprietary equipments that are, like, let's say, public health with those technical X-ray equipments, and they needed parts. So we do issue those every fiscal year, and we list down these equipments that we currently have in the government, and that, if they're interested, please submit a show of interest, so that we will know if the department submits a request under sole source, that we know there's somebody already interested, and we won't authorize the sole source. So GSA is currently doing that, just for informational purposes.
The complaint that I keep getting on this area is it goes out with a replacement of specialty parts and then advice that that's outdated. Why don't you just upgrade it? And then all of a sudden you get brand new machines that 2 years hence need specialty parts that will get an upgraded machine rather than, because it just keeps going in this way. So there has to be some kind of protection in this area, and whether it's the notice or just an outright prohibition, I don't know. But it is something that I keep getting calls on that kind of backdoor way of all of a sudden you've got generation X machine when you started out with A 15 years ago. And
Yeah.
Let me ask, what is the downside for eliminating sole source? There isn't any, because they can go through competitive sealed bid, and if there's nobody else, they just won't bid. You can advertise these things, and so the comment that you give notice to it kind of gets problematic, because you know how they write those things. They write them very vague as to what are you issuing this sole source thing for. Now, that's not anything I can do because of the way it's noticed. So by just eliminating it, and it's got a lot of appeal to me, John's recommendation did as well, there is no downside because you can do a competitive sealed bid or an RFCP.
And there have been instances where only one bidder has been. I don't view that as a sole source because it was advertised and nobody else but one bidder came in. I don't view that as a sole source contract because it was open and nobody else cared to bid.
As well, when there is only one bid, there are regulations that require the government to go through a few steps to assure itself that it's got a fair and reasonable price for the product. So the chief procurement officer has to take some steps if she has one bidder to make sure that it's still competitive. And so there's already law and regulation designed to just not even have that process and put the bid out. However, there is one downside. It probably costs some money for the government to go through the invitation for bid process, but it is the cost of doing the business, and it should simply be budgeted. So that'd be my view.
Additionally, when you're talking about what's a downside to not having sole source bid, well, there is one. There is a provision. I've only encountered it once in 20 years of practicing on Guam. It was with GPA. When you put a bid out, an IFB, and essentially there are no bidders whatsoever, and you still need that piece of equipment. There is a provision in Guam procurement regulations that authorize, only in that circumstance, for the agency to then proceed with sole source procurement. In this case, GPA did put out a bid for I forget what it was, had something to do with a power plant, and it was so technical that nobody submitted a bid, and what we wound up doing was following the reg and going off island, actually outside the United States even, and sole sourced it then. But we could only sole source after we had gone through the IFB process and nobody submitted anything. So if you get rid of sole source bidding completely and you get rid of that regulation, or it's my opinion, you shouldn't get rid of that capability, okay, for sole source after no one submits a bid, okay? That should be preserved. But it's very rare, like I said, that you're going to come to that. I can only think of one instance.
We had an incident in dealing with audit for Chamorro Land Trust and Ancestral Land Commission. We had to go out 3 different times, okay, because on the first time, nobody bid. I knew that there was not a sole source for auditing. Okay, nobody bid. It was because the nature of this and talking it up and getting. The second time, we had one bidder, and the bid was so high, it was in the stratosphere. Then finally, the third time, and it took us 2 years to get that bid out. But that I never viewed as a sole source because I know that and it's just a matter of talking to prospective area. Hey, think about this and doing it. But I knew there would never win the argument that I had to do a sole source contract for auditing. Could never win that argument, even though it took 3 times before we finally got 2 bidders on the third try. Because the second bid only had 1 bidder. But like I said, it was the fee was in the stratosphere. Then the third time, we had 3 bidders, actually, 2 local and 1 off island. So it does take time, but again, that could never have been viewed as a sole source contract, even though it took a while.
Well, there's no further discussions on this, Mr. Chairman. I would suggest then that we basically leave the books open for another 2 weeks for testimonies to come in. and then from there we can determine if we need to do another roundtable. Yes, ma'am.
224 seems to be moving along further. I hope we don't hold back 224 because of 246. You know, that would be my only, because 224 is more substantive to the protest there. 246 is more about the mechanics of solicitation. And if we get subject to clarification on the regulations, because that's the big issue, you know, if we can resolve that time, and if there's no further commentary on 224, and to meet your comment, that at least get one of these out, right? Rather than don't hold the other one because, you know, it has more time. I would like to suggest that you consider, you know, and moving one further ahead than the other.
Okay. All right. I want to thank everyone for coming, and hopefully you'll find time in the next 2 weeks to submit whatever comments you may have on Bill 246, and if there's still any more to cover on 224. Otherwise, I think 224 is pretty much ready to it's just a matter of putting it in the proper form.
I guess, I'm sorry, John Thomas raised a question or an issue with me the other day about a protest bid and stuff, but I suspect a protest bond. I assume that's off the table because I think that would be a bad idea since it wasn't raised today. No.
Yes, I was opposed to it from the get-go.
Oh, okay. All right. I didn't know if it was lurking out there, so I thought
It was, but I protested vehemently.
Well, I agree with you on that one. I think, you know.
Okay. Chairman?
Okay. So we're adjourned, and we'll notify everybody when next is.